Disclaimer. The comments made in this video are intended solely for entertainment purposes and are not intended to harm or offend anyone.
From paternity disputes that unravel hidden truths.
Literally about 2 years after Tyler was born, you did tell me, I cheated on you. He's not yours. You've told me that at least 5 to 6 times.
To heated courtroom battles over child support arrears.
Why did they remove the children from her? Do you know?
For a couple of reasons. One, because she lost her house, the housing house given by the state.
We're diving into a series of family court cases where judges take a tough stand in enforcing child support and custody orders in family court, starting with Mr. David Thompson, the father, and Ms. Stephanie Mendez, the mother of 2 children, Caleb and Tyler Thompson. Mr. Thompson is seeking clarity on his role and responsibilities concerning Tyler, the younger child.
The state calls Miss Stephanie Mendez. Can you state your name to the court?
Stephanie Mendez.
What is your relationship to the children in this case?
I'm their mother. Okay. I've been financially supporting them on my own since 2015.
Can you state their names and ages?
Yes, Caleb Stephen Thompson, 12/9/10, and Tyler David Thompson, 1/20/13.
Who is Tyler's father?
David Thompson. David's been aware that's his son since, he signed his birth certificate. He was there the whole time.
While he has been active in the children's lives and provided regular weekend visitation, there were disputes about whether Tyler was his biological child. This was clarified through DNA testing, which confirmed Mr. Thompson's paternity.
All right, go ahead. Go ahead, Ms. Tari.
At this time, Your Honor, the state would offer into evidence, which been marked as State's Exhibit Number 1. It is the DNA testing report regarding the child Tyler Thompson, Mr. David Thompson.
So, Ms. Mendez, while I'm getting a code to unencrypt, did you have an opportunity to review those results?
I have not. I was informed by the Attorney General that it was a 99.99%.
Mr. Thompson, have you had an opportunity to review those results?
Yes, the lady before, when I was in the pull-out room, she showed them to me. I was never sent them before, but yes, which I was happy to see, honestly.
Do you have any objection to the DNA results being admitted into evidence?
No, I mean, they pulled it from, I guess, the last time when we did Caleb. Okay. So, I mean, DNA doesn't change, so that's fine.
Ms. Mendez, do you have an objection to the DNA results being admitted into evidence?
I do not.
Just since you don't object, I'm going to go ahead and admit them into evidence as being part of the court record.
Have you ever named anyone else as the parent of Tyler? As a father?
I never named him as a father. It was in question, so we went about that route to eliminate him to go to the next process.
When did you tell Mr. Thompson that there was a possibility he was the father of Tyler?
Mr. Thompson has never known about him being an impossibility of being the father. He's always known he's the father. I only privately shared that.
My question is, when did you tell Mr. Thompson that there was a possibility he was the father
Less than
of Tyler?
2 years ago, David's always known he's the father, so I don't know. I don't understand the question.
When did you tell him that you're pregnant with the possibility that he's the dad?
As soon as I found out.
As soon as you found out you were pregnant?
Yes.
Okay. So I announced to the court a number of agreements regarding conservatorship, so the rights and duties visitation. Are you in agreement with what I referenced to the court earlier?
What was that reference again?
So are you in agreement that this order regarding conservatorship, rights and duties, and visitation should look like it does for Caleb, but this time include Tyler?
Correct. Yes, I'm okay with that. They go to their dad's house every weekend.
Okay. Specifically for Tyler, how old is he?
He's 10.
Okay. And how often has he already had overnights with Mr. Thompson?
Yes, David comes and picks him up on Friday evenings after they get out of school, and then he drops him off on Monday mornings at school. Has been the routine.
How long has that been the routine?
Yeah, that's been our routine since 2014, since all of our separation started.
So he's been exercising this type of visitation since 2014?
Yes, and he's been an active, he's their dad. I mean, we had troubles in 2014, but so he does visit them and every weekend. We try to keep their system normal every week as much as possible due to their autism and whatnot.
During the past 48 months, so 4 years from today's date, has Mr. Thompson provided you any assistance for specifically Tyler?
Not financial assistance, but like picking them up on the weekends is helpful because then I can go to work and provide for them. But that's just as general visitation, which is why I schedule my work time around the weekends because I don't have them. They're with him.
Are they with, and specifically Tyler, is Tyler with him every weekend?
Yes, unless he goes out of town. He takes at least 4 vacations a year. So I will tell him it's okay to drop them off at my house. He'll buy them some canes, maybe give $50 extra, which is far and few between, if at all. But that's the latest routine that we had set in stone. But yeah, he's at his house every weekend, faithfully. Has
and
been
for
since
how long
2015.
has he been having Tyler for visits every weekend?
Since 2015. He goes to Disney World with them when he took them on his vacation one time.
So how long has Mr. Thompson been acting as
His
Tyler's
whole life.
father?
Since 2013. He was there the day of the birth, signed the birth certificate. It wasn't in question until I went and pulled up some old medical records. And again, I kept all that to myself. The first and only people I shared any doubt with was Attorney General, just because I was
married at the time that Tyler was born?
Well, I was legally married since I was a teenager. I just never had the money to get a legal divorce. I was with David for about 11 years, and then we consumed 2 child through that 11 years, which is Caleb and Tyler Thompson.
At this time, Your Honor, I would offer what's been marked here for identification purposes. It states exhibit number 2. It is a financial activity report in this case.
Mr. Thompson, have you seen the financial report?
I went over, I guess, some numbers with I forgot her name, the woman I spoke with a little while ago in the breakout room. She had said...
So my question is, it's being offered as an exhibit. So I'm just asking if you've seen it and if you have an objection to it being admitted into evidence.
I have not seen it. All I went over was what she proposed the numbers would be by adding Tyler to the monthly child support.
Okay. Same question for you, Ms. Mendez. Have you had an opportunity to review that exhibit?
I have not, no.
I'm going to put it on the screen. So this is what's being offered as states exhibit number 2. It is the financial activity report.
Oh, yes.
Oh, yes, I did get that, Your Honor.
I just didn't know the title of it.
Okay. So is there an objection to this being admitted into evidence so it can be considered for the record?
Okay.
I don't have an objection to it at all.
I had some questions about it, but I mean, is that what you're asking? Can I speak about it, or are you just saying, can you?
Well, what is the objection, the legal objection you have as to this document being part of the record?
So I was just curious. I noticed no, she clarified that. I'm sorry.
Well, it doesn't sound like you have an objection to the particular record in terms of what child support was due, what child support was paid, and the balances that are reflected.
No, I don't have any objection from that. It's just the amount of the deduction increased, and I wasn't informed of it at all. So that can be explained, I think, by the Attorney General's office. But just very quickly, the state does have the authority to issue with income withholding orders to collect on arrears, and they can change those amounts administratively. Okay.
I do not have the jurisdiction to.
Gotcha. That's
change.
all I needed to hear. I didn't know if this was the place.
So, Ms. Mendez, did I hear you correctly that you did not have an objection to the record?
This is correct.
Okay, so state's exhibit number 2 is admitted.
How are your children currently covered with health insurance?
They have insurance through Medicaid. So, I mean, I go through Medicaid through their stuff. So I think they take out a certain amount every month out of child support to get that paid back.
Do you have access to private health insurance through your employer?
They're full. No, I tried to do that already. I didn't. So I went through the CHIP program, but instead I went through the Medicaid program. They're fully insured already, which
do you have dental insurance available through an employer at a reasonable cost?
It's at a reasonable cost through Medicaid. So I think they're just getting their arrears back from David Thompson.
I'm gonna re-ask my question if you could listen to it. Do you have dental insurance available through the employer at a reasonable cost?
I do not.
So regarding the state's pay record, just so it's clear, the only amounts you've received directly from Mr. Thompson are those amounts reported through the state disbursement unit through this pay record.
This is correct.
So you testified earlier that, once in a while, Mr. Thompson will bring, give the children $50. Can you clarify
Or
what you
sometimes
mean by
like
that?
100. He'll sell 100 if if it's weekend and he's going on vacation again. He'll offer to give us $50 or $100 every now and then and buy some canes for the boys.
Who does he give the money to?
He just sends it through his Zelle account through my bank.
So it goes to you, not the children. Is that correct?
This is correct, but it goes to my children.
If you had to guesstimate about how many times or how much Mr. Thompson has done that, could you what amount would you come up with?
I would probably say about $300 to $500 max, and that's overestimating. Like in the last 4 years.
Okay. And then just to clarify, have you
Maybe
ever
5.
told Mr. Thompson, during this past 4 years that he was not the father of Tyler?
I've not.
Okay.
The only
Pass this
time
witness
was
at this
about
time.
a year. Oh, I'm sorry. Go ahead.
All right, Mr. Thompson, the state has passed the witness. Ordinarily, if you had an attorney, your attorney would be able to ask questions of the witness. Do you have any questions for Ms. Mendez?
Yes. So I was wondering, I've asked you a few times, do you have proof of the Medicaid? I mean, I'm paying for that. I've never seen the Medicaid card or any proof that they actually have health insurance or dental.
What? David, I send you information all the time as soon as they get their
I saw a
checkup.
screenshot in a text that says denied for all two of their names with your name. That's the only screenshot I got from you.
That's negative. They're fully insured and they're fully caught up with all of their medical. So if Attorney General needs to reach out and get that info, they have full access to it.
I've just never seen any proof.
And you're aware, I
pay
call
for
you
that
every
every
time there's an
single paycheck.
appointment.
Okay, folks, look, again, I may have given this speech to the last couple that was in front of me. You are in court, okay? And so
Yes,
we may be on Zoom and you're in your, at your places where you're at, but you still have to follow the rules of court. There's a question and then an answer.
Yes, ma'am.
Okay? There's no arguing back and forth.
Okay. I had one more question. Literally about 2 years after Tyler was born, you did tell me I cheated on you. He's not yours. You've told me that at least 5 to 6 times. So when you said that was a lie. You've told me many times that he's not mine. Out of spite, out of anger, I don't know what it's
Objection, he's testifying. That's not a question.
Mr. Thompson,
have you told me that he's not my father, that I'm not the father?
The interaction between Mr. Thompson and Ms. Mendez is fraught with misunderstandings and accusations. Both parties argue about their respective financial contributions and responsibilities. Mr. Thompson is frustrated with the increasing child support payments and the lack of communication about these changes.
I'm sorry, am I answering David or the judge, or I'm just confused here?
So let's start again. All right, let's not talk over one another because then the question isn't heard. Mr. Thompson, re-ask your question.
When did you first tell me that I'm not the father?
I never told you you were not the father, David, so I don't know where you're going with that. The only person I have opened anything up about that is the Attorney General in a private situation. And then after I felt I was safe, I opened up to you about how we might need to get a paternity test, but it was really hard to communicate with you because honestly, I was scared of you.
So you just said you never told me, then you just said you did.
I didn't.
All
You're being honest
I'm
and God.
going to stop you again. So ordinarily at this point, I would stop the hearing and place you in an in-person docket, okay, because of your conduct. So,
sorry, I'm done. Those are the questions I had. My apologies.
So one more outburst, going back and forth. I have to close this and put you in and recess your case to a different docket where you need to come to the courtroom, where I may have a bailiff that will help me keep order in the court.
Understand.
Ms. Qatar, you may proceed.
The state calls Mr. David Thompson. Can you state your name?
David Thompson, Carlton Thompson.
What is your relationship to the children in this case?
I'm their father.
In my opening, I announced to the court that there was agreements you had regarding rights and duties and visitation. Are you in agreement with what I stated to the court?
As far as, yes.
Okay.
Same thing.
Now, regarding current child support, are you currently working?
Yes.
And how long have you worked there?
Coming up on 5 years.
I said that there was a stipulation that your gross was about $7,233.33. Is that correct?
My check
Wow.
is $28.33 per check. I'm not sure where that number comes from.
How often are you paid?
Bi-weekly.
Okay. And are you
That's
referring
before taxes.
Okay. What's your hourly, or are you a salary employee?
It's right at 62,000, and some of that might be in some commissions, which I get a commission maybe one quarter, and then I don't get commission the whole year. There's some years are maybe 70,000, some years are right at 62. It just.
Did you file your taxes last year?
Correct. It was
Okay.
77 last year.
70. Your reported earnings were 77 last year.
Correct. So I had 2 commissions last year.
Okay.
Two-
And
two
are you
quarters I
still
did not.
doing? Are you still doing that same type of work you did in 2022?
Actually, I've been promoted, which I don't know if it's really a promotion, to sales manager, which is why I got 62 instead of 55. But it's going to be really limiting my commissions now because my sales guys make all the calls now. So I don't know how that's going to play out, but.
So in 2022, you made 77,000. In
2020.
2021, what was your income?
66.
Does that include
That includes
commissions?
everything, yes, because I only had a small one that year and literally nothing else because that was COVID year, of course.
In 2020, what was your annual income?
I didn't have commissions that year. It was 54.
So 2020 was just a base salary.
Yes.
Okay.
That was tech support.
So starting in 2020, when did you get promoted to sales manager?
Literally 3 months ago. Yeah, in July, I think. Yeah.
And so 62,000 reflects just your base, no commission.
Correct.
What do you expect your year to date will be? I know, there's 2 more weeks in the month.
Right
about
around
3.
the same thing as last year, probably.
Do you expect it to be about 77?
Yeah. Mhm.
Do you have private health insurance available through work?
No.
Are you a W-2 employee or self-employed, or how are you paid?
W-2. Honestly, I can't afford health insurance right now. After taxes, I get $1,800 a check, and then I have.
Do
a
you
mortgage.
have any additional children outside of this court order?
No.
Specifically for Tyler, for the past 4 years specifically, when did Miss Mendez tell you that there was a possibility you were the father of Tyler?
When he was about 5 years old. Was the first time during a fight.
And how old is Tyler now?
He's 10. He's coming up on 11 in about 3 weeks.
Okay, so you learned about 6 years ago. Okay. In that window, did Miss Mendez ever tell you there was a possibility you were not the father of Tyler?
Yes. I thought that's what you just asked.
No, when did Miss Mendez tell you?
That was 5 years ago when he was about 5 during a fight.
So
then I'm
okay,
not the
let's
father.
clarify.
Sorry.
Listen to my question. When did Miss Mendez first tell you there was a possibility you were the father of Tyler? You were the father, not any.
When she was pregnant, yeah.
Okay.
She said
Now-
I'm pregnant. Yeah.
Okay. When did has Miss Mendez ever told you there was a possibility you were not the father of Tyler?
Yes, when he was about 5.
Okay, so that was about 6 years old.
Correct.
6 years ago.
6 years ago.
A significant portion of the hearing is dedicated to retroactive child support. The court is examining whether Mr. Thompson owes back support, with the state requesting $16,578.84. There are also disagreements over changes in child support amounts and the adequacy of Mr. Thompson's contributions.
Years ago.
Okay. Regarding the issue of retro for 4 years, what are you asking the court to consider regarding retroactive child support, the possibility?
I mean, honestly, I've already been paid. I already paid $12,000 since Caleb's judgment, which got it down to $15,000. It was $26,000 when we started.
So you're talking about payments you've already made for your initial
Correct.
order. with
I'm
Caleb.
Correct.
Okay.
So I've already paid a ton. I mean, if we increase this, I'm going to be paying $1,500 a month. You know, I have to be able to survive so my kids can come to my house 3 nights a week. Honestly, I handle all of their school stuff. She probably doesn't even know there's a field trip this year.
Oh, here we go. So he's going to put my
okay, we're not gonna
parenting
get into that.
down.
Let's not get into that. Let's not get into that.
Ms. Katari, I'm going to stop
So-
in here. I gave admonishments and they were not followed.
The judge repeatedly admonishes both parties for interruptions and unprofessional conduct, eventually deciding to recess the case for a more formal in-person hearing due to the disruptive behavior.
So we're going to recess this hearing. I'm going to
I'm sorry, I thought we were
schedule
talking.
an in-person hearing. No, Ms. Mendez interrupted. So my admonishment went to both of you. My admonishment was, I don't want to hear any interruptions, no outbursts, and Ms. Mendez did not follow that.
While
So-
Mr. Thompson is seeking clarity on his role and responsibilities concerning his son, Mr. Garcia and Ms. Sanchez grappling with a dispute over child visitation and support. Mr. Garcia's desire to see his child and the financial obligations tied to that. Ms. Sanchez is adamant that Mr. Garcia should have no overnight visitation with Noah due to concerns about his past behavior, which she alleges included drug dealing. Meanwhile, Mr. Garcia is struggling with the proposed child support amount and the overall terms of the visitation schedule.
We're hearing cause number DF 2407775, Garcia and Sanchez. With the parties in the Garcia and Sanchez matter, please unmute yourselves, turn your cameras on, and raise your right hands. Do each of you solemnly swear or affirm that the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth? Mr. Garcia?
Yes.
Ms. Sanchez?
Yes.
All right, you may both lower your hands. And Ms. Peoples, you may proceed.
Thank you, Judge. We're on an order in suit affecting the parent-child relationship. There's a disagreement as to the visitation and then child support. If I could read the proposed order and then take testimony.
You may.
Thank you, Judge. There's one child before the court, Noah Raul Garcia Sanchez. I'd offer the acknowledgement of paternity as State's Exhibit A, which was attached to the pleading on file.
State's Exhibit A is admitted.
Thank you, Judge. The order appoints both parents as joint managing conservators, with the mother having the exclusive right to determine the residence in Dallas or any contiguous county. Judge, there's a standard possession and access schedule in the court order. As far as the support, there's one child before the court, and Mr. Garcia has no other children, so his child support is set at 20%. Mother is to apply for or maintain government medical, cash medical support, Judge. It's $366 a month, beginning August 1st, 2024. And child support, Judge, is $615 a month, beginning August 1st, 2024. There's no retroactive child support, medical support, or dental support. Court costs as billed to Mr. Garcia. And that is the extent of the order, Judge.
Okay. You may call your first witness.
I'll call the mother, ma'am. Can you state your full name? Citlali Sanchez. And Ms. Sanchez, did you hear all the terms of the order that were stated to the court? Yes. Did you understand all those terms? Yes. Okay. With the exception of a standard visitation schedule and the child support, you're in agreement with all the other terms of the order? Yes. Okay. And so you understand the proposed order gives Mr. Garcia standard visitation. You understand that? Yes. And you disagree with him having standard visitation? Yes. Okay. What are you requesting for visitation? Well, let me ask you this. Do you not want Mr. Garcia to have any visitation with your child? No, I don't. So why are you not wanting him to have any visitation?
Because I don't want nothing to do with him. Or I don't want him to see Noah because he wants a DNA test.
Okay, how old is your child?
He's 8 months.
Okay, has Mr. Garcia seen him in the past 8 months?
No.
Do you have safety concerns with Mr. Garcia having visitation with Noah?
I just don't want him to take him by on the weekends.
Can you tell the court why you don't want that?
Because he be selling drugs at his house, and there's people coming in and out.
Okay. And you're not in agreement to any form of like a modified visitation schedule?
No.
Okay. So you're just asking the court that he does not get any visitation at all.
No.
And for how long are you asking that he not have visits?
Ms. Sanchez's refusal to allow Mr. Garcia overnight visits stems from her belief that he was involved in illegal activities, which she claims she knew about even before Noah was born. Her stance on denying visitation appears to be rooted in past grievances and concerns for her child's safety, although the judge has noted that she made these allegations when she was still living with Mr. Garcia.
I mean,
Yeah.
he can see him, but I just don't want him to take him on the weekends.
You don't want him to have overnight visits?
No.
Are you okay with Noah coming to his house at all?
No.
Is there anything specific that you're asking the court to do as far as the visitation?
No.
Okay, and you understand that the order does propose child support of $615 a month for Mr. Garcia to pay beginning August 1st, 2024. Do you understand that?
Yes.
And you disagree with the child support of $615 a month?
Yes.
What are you requesting the child support be set to?
Oh no, that's fine.
Okay, so you agree with the child support of $615 a month?
Yes.
Do you have any safety concerns with your address being listed in today's court order?
No.
I'll pass the witness, Judge.
Ms. Sanchez, you say that Mr. Garcia sells drugs out of his house. How do you know?
Because when I used to live with him, he would be selling drugs, and that's why he's on
Oh, okay.
probation.
You answered my question. And how long did you live with him?
Like a year.
Okay. And when did you stop living with him?
When Noah was 1 month, I left like on December.
Okay. But you knew when you conceived Noah that supposedly Mr. Garcia was selling drugs out of his house, right?
Yes.
And you still chose to have a child with him, correct?
Yes.
Okay. Anything further, Ms. Peoples, of this witness?
No, Judge, if I could call the father.
You may.
Thank you. Mr. Garcia, can you state your full name?
Raul Garcia.
And sir, did you hear all the terms of the order that were stated to the court?
Yes.
Did you understand all those terms?
I was trying to see if I could maybe lower my payments or something like that.
Okay. But as far as all the terms that were stated, do you understand them?
Yes, ma'am.
Okay. And so with the exception of the child support amount, do you agree with all the other terms of the order?
Yes.
Okay. As far as the child support, you understand that the order proposes you pay $615 a month beginning August 1st, 2024. Do you disagree with that amount?
Yes.
What are you requesting the child support be lowered to?
He's concerned about the $615 monthly child support, which he feels is burdensome given his current financial obligations.
Maybe like at least like $125 a week or something like that, because I still got to pay insurance.
Okay, why are you requesting the $125 a week?
Because I have a truck I got to pay. I got a truck I got to pay. I got a probation I got to pay. I got to pay for my cost of living, and I pay rent. I pay bills. I got to pay for my own clothing, and I got to put gas. Food is not cheap no more. Everything went crazy high, so it's kind of making me bump my head here and there.
And then as far as the visitation schedule, you're in agreement that Noah would come to your house and stay the night every first 35th weekend?
Correct.
Okay. And you're not in agreement to doing a modified schedule for your visits?
No.
Okay. I'll pass the witness, Judge.
Okay. So I'll accept the agreement of the parties so far as there is an agreement. I'll make cash medical support $200 per month. Can you tell me what child support will be if I change cash medical to $200 a month, Miss Peoples?
Yes, Judge. So the child support would then go to $647.
The judge has taken a balanced approach by initially limiting Mr. Garcia's visitation to daytime hours only, allowing time for Noah to adjust and for Mr. Garcia to reestablish himself as a stable presence.
As far as visitation, we'll do a standard visitation schedule with no overnights for the first 2 months. After that, it goes to standard.
So I don't get to see him. I don't get to have him overnight on the weekends.
Not for the first 2 months, but then after that, it'll be standard. You can have him during the day at your house, unsupervised, just no overnights until you have complete, Miss Peoples, until he's completed the first 5 visits.
I would like to say,
yes, sir.
What she's saying about me selling drugs and all that, I've been on probation for 3 years, never been dirty. My PO comes over to my house and she checks my house throughoutly, and I've never had no problems. I've been good for 3 years. No drug test been clean.
Have you seen the child in the last 8 months, Mr. Garcia?
Last time I seen him was March 12th.
So the reason I'm giving you no overnights is because he hasn't seen you in a while and he's a young child.
Understandable.
Just giving him time to get used to you again, okay?
Understandable.
That's it. No other reason.
All right, that's fine.
Okay.
Thank you very much.
Anything further, Ms. Peoples?
Just a question for clarification. So, Judge, on the first 5 visits, is it a certain time frame, or is it just going to be the first 30?
8 hours each Saturday and Sunday. Like you can do 8 to 5 Saturday and Sunday for the first 5 visits, and then it goes to standard.
Where can I pick him up at? I don't want to be specifically pick him up at her house, because her mother is always talking some kind of nonsense, and I don't want to have no problems while I'm on probation, and I don't want her to like get me in trouble. Then I lose whatever I have going on.
I'm gonna tell you, we can do an exchange location, but if they don't show up with the child, what you gonna do, Mr. Garcia?
I guess, what can I do?
Not a lot. You can file a case against them, but I would tell you, just go to the house, pick your child up. They just need to hand you the child, and you need to go on about your business. You don't even need to go in. You can stand on the front porch. They just need to give Noah to you with his bag. That's it.
All right.
There needs to be a lot of conversation. Hello, how are you? Thank you. I'll have him back when I'm supposed to have him back. That's it.
That's fine with me.
Okay. Miss Sanchez, do you understand?
Yes, I do.
Okay, and it should not be between him and your mother or him and anybody. You should give him the child with the child's bag and go on. Okay?
I got one more question.
Yes, sir.
How would I know what he like, as in food and all that? What would I have to like?
So that's where parenting comes in. You guys have to talk to each other about those kinds of things. When I said no discussion, I meant no discussion of erroneous stuff. But you guys must talk to each other about parenting, what he's eating now, how, what should I feed him? If she doesn't want to give you the food, then ask her what you should buy.
I've tried talking to her. She's never communicated with me. I'm asking for my son here and there.
Mr. Garcia, I can't make people be adults. I can only give you a framework in which to work with. And that's what this order is. I can't tell you everything to do.
Understandable.
Okay. Anything further?
So what would I be paying every month?
Regarding child support, the judge decided to keep it at $615 per month, but adjusted the medical support to lower the overall financial burden slightly.
$847.
$847?
Yes.
That's including insurance?
Yes.
Okay, that's fine.
Okay. Anything further?
Is there any way I can lower it?
So I did lower it when I lowered the insurance amount.
Okay, that's fine.
Okay?
All right.
All right. Anything else? All right, then good luck to both of you. Thank you for appearing here today, and you're both free to go.
As Mr. Garcia and Ms. Sanchez work through their visitation issues, Michael and Chelsea Rodriguez face their own challenges with custody schedules and school choices. In this clip, we see a heated court hearing between Michael Rodriguez and Chelsea Rodriguez, dealing with issues related to custody, parenting time, and the children's schooling.
Record this matter is before the court on the plaintiff's motion to modify custody and or parenting time, as well as motion for order to show cause. This hearing is being conducted via Zoom. The present is the plaintiff father, Michael Rodriguez. In addition, attorney Stephen Rotenberg is present, representing defendant mother, Chelsea Rodriguez. Ms. Rodriguez is present. Good morning, everyone.
Good morning, Judge.
The parties have conferred at length with Ms. Brower from the front of the court this morning, who has provided the court with the following recommendation: that both parties must submit proof to the front of the court and the court that the SMILE program and the High Conflict Solutions Workshop have been completed within 7 days. Children shall attend Monroe Public Schools as previously ordered. Mother shall ensure the children attend Monroe Public Schools no later than tomorrow, September 5, 2024. Mother shall not leave the children unattended for any period of time during her parenting time. And finally, that show cause be dismissed. That is the recommendation. Mr. Rodriguez, do you understand the recommendation this morning?
Yes, sir.
Do you have any objection to the court adopting the recommendation?
Michael Rodriguez is frustrated with Chelsea Rodriguez for not adhering to the agreed parenting time schedule. He claims Chelsea has failed to show up for scheduled exchanges, leaving his girlfriend waiting for over an hour and failing to answer calls. This has led to significant communication breakdowns and disrupted parenting time.
No, the only thing I ask is for like the drop-off time is if she can come pick up her children when it's her time, because I've had my girlfriend go out there and she's failed to even show up to where it was for over an hour and then doesn't answer anyone's calls when it's time to pick up my children. And this is the main reason why, because she keeps keeping them against me or just leaving them alone.
None of this was brought up. None of this was brought up in front of you.
I just filed a complaint, Stephen. Yes, it was brought up.
It was not brought up. Not in this motion.
Well, it's in the courts. So the complaint I just filed shows all that.
That's not up for today. That's not relevant for today.
I had the police number and everything if you guys need it.
If there's an issue with exchanges, we'll address that this morning.
That's fine. Yeah, that's what I'm trying to address.
Every week. So if there's an issue regarding exchanges and the time of exchanges, we'll address that this morning.
Okay.
Hold on, Mr. Rotenberg. Hold on. Ms. Brower, trying to go through this thick file here. Is there any time where the parties meet right now for exchanges or where they meet? Perhaps they should meet at the law enforcement agency at a certain time?
Your Honor, I believe that they meet, it's in a recent order. Just a moment.
It's at the Canton Police Station at like 6 o'clock.
Mr. Rodriguez, where do you propose that you meet for the exchanges? And I'll ask Mr. Rotenberg what he proposes.
Well, I'm just asking. She says she has off like an hour throughout the day here and there. So within her hour on my time, if it's possible, she could bring them to me during the day, and then my girlfriend watches them like it's been previously stated throughout the day until I get off of work. But
Judge,
she just fails.
Please, I'm not going to interrupt you. Please do not interrupt. Otherwise, we're going to mute you. Please.
But yeah, so the last time I was supposed to pick up my children, it was probably about 2 weeks ago. My girlfriend went to pick them up at the Canton Police Station at around 6 o'clock, like we're supposed to. And Chelsea was just nowhere to be found. I texted, called, no answer. And probably till a couple of days ago, she finally answered me. I just haven't got a chance to even get a hold of my daughter. I don't know how my kids are doing. Yeah, I'm just confused on what's going on right now. But if she can meet me, if she can come this way for her children when it's time to pick up, I'll drop them off to her. That's fine when it's her time. But she can pick them up when it's her time. But I'm not, I feel like it's just...
You can't communicate with Ms. Rodriguez about these simple things?
No, I can't. Unfortunately, he won't answer me.
Your Honor, if I may.
Chelsea, sorry. I thought it was Chelsea.
Ms. Brower?
Referee Hamrich on August 14th recommended that the parties exercise all parenting time exchanges at the Flat Rock Police Department. That 21-day objection period ends this Friday. Neither party has filed an objection to that as of today.
All right, so I got to file an objection.
I'm sorry, that was in August?
August 12th.
Recommended order?
August 14th. It's a recommendation at this point. I don't believe the court has it in its file.
Yes, now the court's file. And that provided the parties meet at where the Flat Rock Police Department?
The Flat Rock, yes.
At what time? Does it have specific times?
It does not.
Okay.
The parties would follow the previous court order for parenting time. I believe that gives father alternating weekends, Thursday at 6 to Monday to school or 9 a.m.
Okay.
Your Honor, if I may, the front of the court also did an investigation and recommendation as far as parenting time. Neither party has motioned the court to adopt it, but the front of the court's recommendation is to give mother alternating weekends, Friday at 6 to Sunday at 6, and that the children remain in Monroe Public Schools.
And Judge, we would object to part of that recommendation, and I'll explain why.
Well, if you got an objection, Mr. Rotenberg. I mean, in front of the court, the referee recommended order, that will take effect if there's not a written objection filed within 21 days.
Right, we're mixing, okay, I think what we're doing is we're mixing recommendations and orders a little bit, that there's multiple ones out here. This morning, Ms. Brower recommended, or is about to recommend, that the children remain in the Monroe Public Schools and the parenting time remain as follows.
Chelsea has recently moved to a new location, which has impacted the logistics of where the children go to school. She wants to enroll the children in Canton Public Schools, closer to her new home. This change is causing tension because Michael Rodriguez wants the children to remain in Monroe Public Schools to avoid long commutes and maintain stability.
MCL 722.31 is the 100-mile rule, and that allows a parent to move within 100 miles without the court's permission. Ms. Rodriguez moved to Canton, which is about 40 minutes away by car from city center to city center from Monroe, to get a better job, which is in the best interest of the children. If she was to keep the children in Monroe Public Schools, that would force her to drive back and forth to Monroe 4 times or do 2 round trips a day during the school year. The kids would be in the car for at least an hour and a half a day more than they otherwise would be. They would not be able to participate in extracurriculars near where they live during the school week, and it would interfere with their ability to make friends with their new schoolmates in their new neighborhood. Now, Ms. Rodriguez probably should have asked for the court's permission to change that order to change where the children are enrolled. But there's no real difference that I know of between Canton Public Schools and Monroe Public Schools. And I think it would be in the best interest of everybody, wear and tear on the car, reducing the amount of travel time, reducing the amount of driving, because these children, I think, might go to different schools. I'm not sure if they all go to the same one or not. But as a practical matter, it puts a huge burden on them to drive in this car going back and forth. Okay, she could move up there without the court's permission. There's nothing wrong. There's nothing all that different that I'm aware of, as I said, between Canton Public Schools and Monroe Public Schools. So I'd say that we adopt the order, except that she can enroll them in the Canton Public Schools, because Mr. Rodriguez doesn't have them during the school week. It's on information and belief he doesn't drive. Okay, well maybe you do. Then I stand corrected. But as a practical Ms. Rodriguez has a better paying job than she had before, earns more than she ever did, has benefits for the kids that she never had. And all this would do is basically force her to have to ask the court's permission to do what she's allowed to do by right, because that previous order might have been a little bit more restrictive than it otherwise should have been. It possibly should have said something along the lines, the public schools where the parties live, or something like that. Because I'm unaware of any inherent property other than geography that would differentiate Monroe Public Schools from the Canton Public Schools. So that would be the extent of my objection to the recommendation. Now, as for all the other, as Mr. Rodriguez, let me finish. Now, as for the other thing we have a bit of chaos here, in that I filed an appearance, and I did send it to Mr. Rodriguez, I believe, on the 12th. The appearance itself says that I request copies of everything filed in this case. I haven't received anything from Mr. Rodriguez. I haven't received his most recent objections. I got that from the friend of the court. I have not received anything, and I requested them, and he's wants to be his own attorney. I would like copies of those files. I haven't received them. The other thing too is it doesn't matter.
You could easily get that.
Mr. Rodriguez, do not interrupt, please.
The other thing too that we have with this is he likes to file objection after objection after objection after objection. Zillions of them, and then he mixes them all up and tries to fight them all at once, and it adds to the confusion of the case. So I don't really see anything other than a power play issue here, favoring Mr. Rodriguez having the children in the Monroe Public Schools if they're near Ms. Rodriguez. The other thing too with this is there's allegation that it's obviously these parties don't get along. But also, Mr. Rodriguez has unclean hands. Both parties were ordered to participate in certain programs. I don't know if my client has or hasn't, but we sure as heck don't know if Mr. Rodriguez has or hasn't either, because again, there's been no proof.
I
He
filed
hasn't
them.
given,
in the court.
again, as the attorney of record, and I am entitled to all filings. And if you want to play lawyer, we're all supposed to play by the court rules. Those are the rules of the road, so we don't have chaos. And this has become one hand clapping. So if Mr. Rodriguez, I would ask that Mr. Rodriguez give me copies of everything that's been filed in this case, number one. Number two, we would ask that the court entertain allowing Ms. Rodriguez to have the children in Canton Public Schools, because there's no good reason to have them driving back and forth an hour and a half every day. Plus I don't quite know what time her shift starts or how this interplays with any latchkey programs or anything like that. I believe Ford starts pretty early in the morning, and I don't know, if memory serves me right, I think it might be a 7 o'clock shift. I don't know how the heck that this would even be feasible. We don't want to endanger her job.
So who's watching the kids?
The kids.
Mr. Rodriguez, can you mute? We're going to mute you, Mr. Rodriguez. You keep interrupting.
And as for who's watching the kids, Mr. Rodriguez, during the school year, if they're in school, it doesn't really matter. They're being watched by school staff. That's what we're talking about right now. If we have other issues with latchkey or daycare or other things like that, we can deal with that at another time. But right now we have a serious issue here as to adding hundreds of miles of road travel to these children's lives every week. And that's not in their best interest.
Thank you, Mr. Rosenberg.
Thank you.
Mr. Rosenberg, without question, Ms. Rodriguez, she can move to Canton. She can. But changing the schools on her own, that is not permissible without this court allowing that. She can't just unilaterally change the school district for the children. Mr. Rosenberg, have you received a copy of the recommendation of Catherine Scott dated August 26, 2024?
I'm unsure, Judge. I do not know. I don't have it in the file in front of me, but that does not necessarily mean I don't have it.
The referee Homrick on June 25th?
Yes, I have that. Yes.
Her recommendation is at the issue of school district, and she denied the request to modify parenting time. She recommended that mothers have parenting time week on, week off during the summers, that they both complete the high conflict solutions parenting workshop, and that the issue of parenting time and choice of school district for 2024-25 school year be referred to the front court for investigation recommendation. Catherine Scott completed a investigation. She issued a report dated August 26, 2024. She indicates that also she interviewed both the children, the 10 and the 7-year-old, who were old enough to be interviewed. That defendant mother failed to cooperate in any way with the front of the court during this first parent time investigation. She did not respond. She was mailed a questionnaire. She was asked to make a phone interview. She did not respond at all or cooperate with the front of the court regarding this investigation. So the recommendation of Catherine Scott is that children attend Monroe Public Schools to provide continuity, consistency for the children. That's where the children have been. Not unilaterally change them to Canton schools where they're not familiar with. And further, that mom's parenting time during the school year be alternating weekends, Friday at 6 until Sunday at 6.
Again, but Judge, if she's got them Friday at 6 till Sunday at 6, it makes no sense. Shush. It makes no sense to force her to drive back and forth. And there is no, and as for consistency with schools, Judge, as you know, every few years you wind up in a new school. School friends and school things are inconsistent. You're in with a new class or whatever. My kids complain, oh, I'm in with my friends, I'm not in with my friends, etc. The fact is they'll make new friends. And as for the consistency from one year to the next, there's no, it really doesn't make a difference. The issue really is just during the school year, because parents pick up and move all the time. So I'm not entirely sure that extra verbiage about consistency, other than amplification, is really justified, because they are enrolled in school.
Right. Mr. Rosenberg, there's been no petition filed with this court to change school districts. Mother has just unilaterally decided she's going to do this on her own. There's been no petition filed with the court to change the school district of the child to make that an issue, and school has begun this week. So the court at this time is of the opinion that children need consistency, continuity, and that they will continue in their current schools, Monroe Public Schools. And Ms. Rodriguez shall return the children to school tomorrow morning, unless you want to bring them back to dad this evening. The court will adopt Ms. Brower's recommendation, and in addition, the court can adopt the recommendation of Catherine Scott. Obviously, Ms. Rodriguez did not cooperate in any form or fashion to respond and provide input from the court. So parenting time for the mom will be week on, week off during the summers. During the school year, beginning this weekend, mom will have alternating weekends, Fridays at 6 till Sunday at 6. The exchange will occur at the Flat Rock Police Department.
Judge, we would ask that Mr. Rodriguez's girlfriend not be allowed to pick up the children, that Mr. Rodriguez himself have to pick up the children.
All right, Mr. Rodriguez, do you have someone else? Obviously, if there's a
No, Mr. Rodriguez himself. Only.
All good. Don't even worry about it. I'll take care of it.
Mr. Rodriguez, do you have a driver's license?
The judge is attempting to address these issues by adopting recommendations from the front of the court. The judge orders that the children remain in Monroe Public Schools and that both parents complete specific programs aimed at resolving high-conflict parenting issues.
Of course I have a driver's license, yes. Yeah, I can meet there. That's fine. No big deal.
So you'll pick up and drop off the children then on drop them off at 6 o'clock on Friday, and you pick them up on the Sunday at 6 o'clock.
Yep.
All right. So we'll put that in the
Friday.
If
we could do earlier,
do all the transportation.
If we could do earlier on Friday, Your Honor, because if I can't have my girlfriend meet, it's gonna have to be earlier on my time then.
Well, we're not concerned about your girlfriend. We're
on Friday, I could do Sunday all day.
No big. 6 o'clock.
No, that's
Friday,
fine. But she doesn't want to meet my girlfriend, so I'm saying I can't do Friday at 6 o'clock. It has to be earlier, is what I'm saying.
Okay.
If that's what she wants, unless she wants to meet my girlfriend.
Okay.
I go into work at 3.
You can't do it, Mr. Rodriguez. Perhaps we can do it Saturday morning.
Okay, so make it 5. Can you do it 5 o'clock, Mr. Rodriguez?
Yes, sir.
All right. So the parenting time exchange will be at 5 o'clock on Friday and 5 o'clock on Sunday.
Perfect.
So
you can bring the kids whenever.
Children to that Flat Rock Police Department. So, Ms. Rodriguez, do you want to take the children to school in the morning? You're going to take them back to you take them to school in the morning. You take them back to Mr. Rodriguez this evening. What makes the most sense?
Well, I work. She doesn't want to meet
Ms. Rodriguez, Chelsea Rodriguez. You're going to take the children back to Mr. Rodriguez. There are children in your possession this morning. Is that correct?
Are they in mine? I'm sorry.
Yes. Where are the children this morning?
They're at school out here.
Okay.
Because
okay.
school started.
The court has ordered they be returned to Monroe Public Schools. Do you want to take them to school in the morning? Or do you want to take them back to Rodriguez this evening?
Okay, Your Honor,
The judge also orders that the children's exchange occur at the Flat Rock Police Department to avoid further disputes.
Okay, respectfully, I need to speak about this because you're putting them in a school district. You think this is consistency?
Okay. The court will order Ms. Rodriguez that you meet the Flat Rock Police Department at 6 o'clock tonight.
Judge,
5 o'clock tonight. So that's not good for Mr. Rodriguez. Exchange children at 5 o'clock tonight, and so that Mr. Rodriguez can give them to Monroe Public Schools in the morning.
No, you're not letting me speak.
Judge,
Ms. Rodriguez, hold on. Ms. Rodriguez, we're going to mute Ms. Rodriguez for a minute. Ms. Rodriguez, if you're saying no to this court, you're not going to play this court order, then I'm going to order you to appear this afternoon in this court with the children. You come down here this afternoon, and we'll start contempt proceedings. If you're telling this court you're going to ignore this court order, then you appear personally in this court this afternoon at 3 o'clock with the children. Do you understand that? Is that what you want to do? You can mute her. You can mute her. Your response. Okay, your response, Ms. Rodriguez?
Respectfully, you're not allowing me to say
Ms.
what
Rodriguez, this court is ordering that you appear with the children at 3 o'clock this afternoon, Ms. Rodriguez. You be here too, so pick up the children. Be down here.
I'm not doing that. They're not.
Mr. Roldberg, if she not appear at 3 o'clock this afternoon in this court, the court's going to issue a bench warrant for Mr. Roldberg. If she doesn't appear at 3 o'clock, the children to appear at 3 o'clock this afternoon with the children.
No.
We're done. Zoom out.
Chelsea, you're showing up with the kids.
While the Rodriguez family deals with logistics, Mr. Salo and Ms. Rodriguez are battling over full custody due to significant changes in living situations. In this clip, we witness a heated courtroom discussion about custody and child support.
And how old are the children?
Maria, she's 16, Esmeralda 13, and David it's 11. He's 11.
And who do the children live with?
With me.
And who makes the day-to-day decisions?
Me.
Does Miss Rodriguez make any decisions for the children?
Not since they've been living with me.
Okay, and when did they start living with you?
September of 2022.
Okay, and Mr. Salcedo, what are you requesting the conservatorship be?
I I don't understand the question.
The conservatorship is who's going to make all the decisions as far as where the children reside, where they go to school. And there's joint managing conservatorship and there's sole managing conservatorship.
No, he doesn't get to decide. It's based on the evidence. So,
right.
Mr. Salcedo, you've had the children since September of 2022, correct?
Yes.
All right. What are their ages?
16, 13, and 11.
All right. Are they currently visiting their mother at any time?
No.
Okay. How is it that you ended up with the children?
Child Protective left the custody to me.
All right. And did you go before a CPS judge, or you were just talking to CPS through their offices?
The offices. I was. They had a representative. Nora.
Okay. All right. And where is Miss Rodriguez right now at this time? Do you know where she is?
She's residing with her parents.
Got it. All right. And so did the CPS workers give you any restrictions regarding whether Miss Rodriguez could visit the children?
No, not to my house, but the children cannot go to her house.
Got it. All right. And did they ever issue an opinion as to whether or not
Mr. Salo is seeking sole managing conservatorship of his 3 children after their mother, Ms. Rodriguez, lost her home and was found to be living with a person who had sexually assaulted his oldest daughter. The judge is tasked with sorting out custody arrangements and child support responsibilities while also considering the children's best interests.
Why did they remove the children from her? Do you know?
Well, for a couple of reasons. One, because she lost her house, the housing house given by the state. And because she's living with that person who sexually assaulted my oldest daughter.
All right. And do you know if she's still living with that person?
Yes.
All right. Now, when was the last time she saw the children?
It might have been like 3 weeks ago.
Okay. And when she sees them, does she see them at your house?
No, she also, Dollar General, we were going to the store and we, occasionally, like it was
you ran into her. You ran into her.
Yeah, we ran into her.
Okay. And so what kind of visitation are you allowing for your 3 children to see their mom?
As for me, because they're old enough, I don't have no restrictions.
All right. But you said CPS said that the CPS case is still ongoing?
No, it was closed whenever they were left into my custody.
Okay. All right, then what we're going to do is I'll grant some sort of visitation as long as it's in a public place. Okay, Mr. Salcedo?
Okay.
Yes, Mr. Feist.
I was going to say, Your Honor, that I was going to go into the, Mr. Salcedo, you were in agreement to the joint managing conservatorship, right?
Well, no,
well, that's
the court. Yeah, I know.
Okay, Your Honor.
But because CPS was involved, they closed the case. I don't have anything other than maybe CPS at one time said she could not see the children at her house, right? Mm-hmm. I don't have any problems with sole managing conservator because of the history of the case. And we could do visitation at a public place and he can decide. If you can just tell us right now, Mr. Salcedo, they're old enough, like you said. The only thing I would do is keep all 3 children together. So is there a public place? Well, let me ask you this. Has she reached out to you telling you she wants to see the kids? Does she even try to see the kids?
I think so, ma'am. Because not to me, but she's talked to my oldest daughter, which she, like, the 2 oldest ones refused, but the little one does try to see her. But yeah, she reached to them, not to me.
Ms. Rodriguez's access to her children is limited. She is allowed to visit them in public places like Maverick County Lake, but no overnight stays are permitted.
All right. Well, we're going to put in the order that she can have visitation the 1st, 3rd, and 5th Saturday from 12 to 6. That's every other Saturday. Just give me the name of a public place that you would be comfortable with.
Probably Maverick County Lake.
Okay. And what you're going to do is I'm going to put a clause in there that all 3 children should stay together, okay?
Yes.
So that your oldest daughter can help with the younger one, okay? All right, we'll just do it that way, Mr. Feist, if...
The judge's decision reflects a balance between allowing some level of contact and ensuring the children's safety and stability.
I don't have any information from CPS other than his testimony, and so we'll just leave it sole managing conservator, but we'll grant visitation.
Okay. Mr. Salcedo, do you have any information as to Ms. Rodriguez's income?
No, like I said, the other worker, no, I don't.
Okay. Then we're gonna, the state's gonna request that the minimum wage presumption take effect. Are you in agreement to that? Minimum wage would, yes.
Yes.
Ms. Rodriguez will be required to pay child support starting February 2024. The court has set the amount at $317 per month, with a gradual reduction as the children reach certain milestones, such as turning 18.
Child support will be set at $317 a month effective February 1st of 2024. Are you in agreement to that?
Yeah, yes, sir.
Okay, there'll also be a step down of $264 and then another step down of $211. Were you in agreement to that? The step down means when one of them emancipates, graduates, turns 18, it'll go, your child support will go down, or her child support would go down.
Just a quick question about that. What if my oldest daughter continues to go to college or so?
It's by the statute, the Texas Family Code only goes up to the 18.
Okay, sure, no problem.
Okay. And how are the children covered for health insurance?
They're in a state Medicaid.
Okay. So the medical support reimbursed to the state will be $100 effective February 1st of 2024. Are you in agreement to that?
Yes.
And you are requesting non-disclosure. Is that correct?
What is non-disclosure?
Non-disclosure means your information will not be on the order, like your address. Does she already know where you live?
Yeah, she knows where I live. We were 17 years together, so yeah, she knows.
Okay. So you are requesting that your information not be on the order, though, correct?
It wouldn't matter to me, as I told you. She knows where I live, so yeah, whatever.
Okay. Also, Mr. Salcedo, we are taking we're doing a confirmation of arrears. There's a medical arrears owed of $2,716.79 with a repayment of $25 beginning February 1st of 2024, and that would be your payment. Are you in agreement to that?
Just a quick question. I was told that's the repayment through the time they're living with me.
That's the time that when they were living with her, right? However, the child support, it will be set. The child support arrears is at 0 as of yesterday after your possession credits. Okay.
Yeah. Okay.
Okay.
So in other words, the amount of $2,716, Mr. Feist, already we're giving him credit for the time the children began living with him from September 2022, right?
Yes.
Okay. Does that answer your question, Mr. Salcedo?
Yes.
Okay.
Oh, Your Honor, also, I have a question. Is it any overnight stays? Are you ordering any overnight stays?
I
don't. Has she ever had them overnight?
No.
All right. No overnight at this time.
Thank you, Your Honor.
Mm-hmm.
I just wanted to clarify.
Yeah, no, good question.
I have no further questions for Mr. Salcedo, Your Honor.
All right. Then based on the testimony, the court will change the prior order and will grant possession of the 3 children to Mr. Salcedo. Child support will be set of $317 with a step down of $264 and $211. This is child support to be paid by Roxana Rodriguez beginning February 1st.
The court also addressed past due support, clarifying that Mr. Salo would be credited for the time he has had the children.
There will be a medical payment. She will have to pay $100 for medical insurance. Arrears is being granted of $2,716.79. That's against Mr. Salcedo to be paid at $25, and that's after giving him credit. He will be appointed the sole managing conservator. She will have visitation the 1st, 3rd, and 5th. Saturday from 12, I think I said 12 to 6 at Maverick County Lake. with no overnight at this time. Court costs.
I did. Sorry,
Yes.
Your Honor. Sorry, Your
okay.
Honor, interrupting. I did have one question which I didn't understand with the work was that since that time they're living with me, she's free to pay anything to me since September 2022.
I'm not sure I understand the question.
Like I being credited for the amount that I was supposed to pay, but she is free to go on anything like for child support from September 22 to this point to me.
Oh yeah, no, I can't go back that far. I can only go back. Well, let me see how far back. Are you requesting that the child support go back since then?
I thought I was, but the worker said that I couldn't.
Okay, let me check. Let me see when this was filed. All right, Mr. Salcedo, this case was filed in September of 2023, but with the first appearance, we were here in
July, I think.
No, it looks like November. Hold on. They filed it in September, asking to change to get you in order so you could begin, so the children could be living with you. They filed it and we were here in November for the first time. November. So we can go back November the 30th. We can go back as far as December 2023. I can't go back further than that, okay?
Okay.
So, but all I need from you is in December of 2023, which was just recently, the children were living with you, correct?
Yes.
And you have had them since then without interruption, right?
Yes.
All right, Mr. Vice, I guess we could go back, but then I don't know how that plays out with the credit you gave him. How far back were you giving him credit? Because it has the same effect, kind of has the same effect, Mr. Salcedo. They were giving you credit. What I mean by that is it's as if you didn't have to pay child support because you had the children. So by me setting it that far back, it may be like we may be doing it twice. So I'm going to let him look at his notes, okay?
The possession credit was $10,848.01, so it was quite a while.
So it's already including it, right?
Yes.
Yeah,
Yes,
Mr. Salcedo, we're already giving you credit. By that I mean like as if you didn't have to pay child support because you had the children, okay?
Yes.
Okay. That'll be the ruling of the court. Court costs will be they will be billed to you, but there will be no attorney's fees, okay? All right, I will sign the order electronically, Mr. Salcedo. That's when it becomes final. Do you have any questions?
Am I gonna receive an email or by letter or the paperwork?
You're gonna get something from the courthouse saying I signed it. So, but it's a little postcard that says I signed the order. You can go pick up a copy at the courthouse, but I think sometimes they'll email you a copy, okay?
Thank you.
Thank you. Bye-bye.
In situations like this, it's clear that the legal system aims to prioritize the children's welfare above all else. If you found these insights valuable and want to stay updated on similar content, don't forget to subscribe to the channel.